Today's program, Lessons Learned, How Case Law Informs Prudent Practice, is intended to give you a sense of how the legal system has disposed of cases involving design professionals in the last year. I want to introduce our speaker for the day, Jonathan Shoemaker. Design professionals are innovative problem solvers. So is Jonathan. Jonathan believes that the best solution to most problems is often the simplest. What does the contract say? Jonathan begins every new engagement seeking to understand how the parties in a construction project elected to allocate risk and responsibility before the project, and then works with his client to develop a plan for bringing the issue to resolution as expeditiously as possible, consistent with the client's goals. Jonathan has tried cases before judges, juries, and arbitrators, and relishes the opportunity to advocate for his clients in court and in arbitration. Jonathan really enjoys getting into the weeds of a dispute, deconstructing the issues presented throughout the discovery process, and then presenting the dispute clearly and concisely to the fact finder. Jonathan's experience includes noteworthy appellate work on behalf of design professionals and the design professional industry, including both advocacy on behalf of parties involved in litigation and on behalf of industry leaders, including ACEC, AIA, AASCE, and NSPE, related to amicus briefing. He frequently speaks on risk management issues, best practices for design professionals, different project delivery methods, and legal updates both at in-house seminars for his clients and at programs put on by design professional organizations and insurance carriers. Jonathan, thank you so much for doing this program for us. Can you tell us a little bit about this program and how you identified the cases that you'll be discussing shortly?
Sure. So good afternoon, everyone. My name is Jonathan Shoemaker. We're a firm that focuses our practice on the representation of design professionals. And so as part of that practice, we undertake every single year a survey of cases from across the country affecting architects and engineers and surveyors, pretty much any type of licensed design professional that there is. And we do that really for two reasons. The first is it gives us a preview of the legal issues that are occurring across the country and maybe making their way to the jurisdictions in which we practice. And secondly, it gives us an opportunity to identify cases that we can then share with our clients to provide an educational opportunity to learn from litigation experiences of other design professionals so that they have the opportunity to learn about issues and risk management strategies through the experiences of others rather than perhaps learning those in the context of a claim situation themselves.
I see. Thank you so much for that. So without further ado, let's get started with the first case that you're going to present to us.
Sure. So we're going to start off with a case which takes us to the Eastern District of Pennsylvania involving DeVita and Tetra Tech. The background of this case is that it involved an owner of property where there was a history of groundwater contamination, which included some solvents which the owner had been using as part of the manufacturing processes of their facility on the property. The case came to us, not to us as the firm, but comes to us in the context of a claim by the owner asserting a claim for negligent misrepresentation against an engineer. Now, that engineer was not an engineer that the owner themselves had retained. Instead, it was the Pennsylvania Department of Environmental Protection who had contracted with that engineer. And the purpose of that contract was to monitor and test groundwater and ultimately issue a report related to the groundwater condition on this property. The owner, after this report had been issued, listed the property for sale, and a prospective purchaser entered into a sales contract for the property. As part of their due diligence on the property, they engaged their own environmental consultant who reviewed both the engineer's environmental report as well as completed their own analysis and recommended that their client not proceed with the purchase as it was because of the groundwater contamination conditions. Ultimately, the owner of the property and the prospective purchaser entered into a subsequent contract with different terms, but one of those terms was that the owner of the property had to reach some type of an agreement to clean up the groundwater contamination with the Pennsylvania Department of Environmental Protection. All of this sounds relatively normal and probably shouldn't result in litigation, but that is unfortunately the world we find ourselves in. And so the owner of the property sued the engineer who had been retained by the Pennsylvania Department of Environmental Protection based on a negligent misrepresentation theory, claiming that the sale was delayed and that they incurred additional costs due to the engineer's report that they had developed for the Pennsylvania Department of Environmental Protection. Why do I keep referencing negligent misrepresentation? Because in order to pursue a claim against a design professional in most jurisdictions, or in many jurisdictions, you may think, I need to have a contract with the person who's going to be suing me. In Pennsylvania and some other jurisdictions, however, a new cause of action has been developed to pursue claims against design professionals, and that is a negligent misrepresentation claim. And a negligent misrepresentation claim is one where there doesn't have to be a contractual relationship between the parties. All it requires is a misrepresentation of a material fact made under circumstances which the misrepresenter ought to have known were false, with the intent to have other people rely upon it and resulting damages. And here, the owner of the property said, in essence, the representations made by the engineer were false and caused damages, and that they were intended to be relied upon by people. The engineer at the close of discovery moved for summary judgment on two grounds. First, they argued, look, our report was not intended to be relied upon by anyone other than our client. And secondly, the owner of the property can't prove that our report delayed any closing or caused them any damage because the prospective purchaser, who became the purchaser of the property, had their own environmental engineer who advised them on the pros and cons of the acquisition. And they relied on their own engineer, not on some report prepared by the department's engineer. Unfortunately for the engineer, the federal trial court denied summary judgment because under the law in Pennsylvania, there were certain permissible exceptions to this general rule that you require a contractual privity, and the court concluded that there were factual questions that would prevent entry of summary judgment, meaning dismissal of the case, short of trial. And so in this particular case, you can see that the trial court recognized a negligent misrepresentation claim, even though there was not a cause of action for contractual or based upon contractual privity. So what's the lesson or takeaway that the folks here can take from this? And this applies regardless of whether or not you're an environmental engineer. There are two things. First, you should be evaluating the risk of third-party reliance on your work product if you're going to go into a new jurisdiction. If you're not used to doing business in a particular state or jurisdiction, there may be unique risks that you want to inform yourself of. If you're going to Pennsylvania, you might have claims asserted against you by parties who you don't have a contract with. The other thing you should be doing is thinking about what type of contractual provisions might I include in my contract that might expressly prohibit those types of claims. So those are sort of two different lessons learned that you might be able to take away from this experience from the engineer in Pennsylvania.
Wow, this is very interesting, Jonathan. In addition to contract language, is there, let's say there's a firm that's writing a report, can they, or do you suggest that they put anything in the report that specifically disclaims the ability of parties other than the client to rely on this information? Do you think, in your opinion, that that could also help?
Well, that's certainly a leading question, Nahom, and
Yes.
absolutely. I think one of the things that most of the folks on this webinar have probably had experience with is receiving a geotechnical report that at the end of it includes all sorts of disclaimers and saying you can't rely on anything we say other than what's the conditions of the borings that we took on a particular date and time. And that type of language is actually, I think, very effective and can be an effective defense if it's included in a report, disclaiming any right for third parties to rely upon the information that's included other than the client, expressly noting that it's subject to the terms and conditions of the party's contract. If you've got good risk management clauses there, even if there's an argument that somebody tries to skirt around the nobody can rely on it provision that you've included in your report, you get to turn to your contract provisions. Nothing's a get out of jail free card in litigation, unfortunately, but the more arrows in the quiver, the better your defense. So the next topic we're going to talk about a couple of cases. The next topic we're going to talk about involves a couple of cases implicating site safety issues. The first one takes us up to Connecticut. In this particular case, a construction worker was injured while working in a trench located in the city's water utility infrastructure. While moving a portion of the water main, a valve failed, resulting in an object striking the construction worker's knee. With the trench flooding with water, the construction worker then began scrambling out of the trench, and as he was doing so, he hit his head and suffered brain damage. The construction worker sued the city and then subsequently asserted a direct claim against the resident engineer after the city pointed the finger in the direction of the engineer. The engineer in this particular case moved for summary judgment on the construction worker's claim, arguing that the Workers' Compensation Act in Connecticut afforded design professionals immunity to claims for injuries sustained on a construction project in the absence of unless there was a specific contractual provision under which the engineer or architect agreed to assume responsibility for site safety. In this particular situation, there was no evidence presented to the court that the engineer assumed a responsibility related to site safety, and so as a consequence, the Connecticut trial court granted summary judgment in favor of the engineer. But what's the lesson to be learned from this? Well, it's not uncommon for contracts with design professionals to include various types of provisions that you may not think apply to you. For example, you may have a client who pulls a construction contractor contract off the shelf, and you just look at it and you say, okay, well, a dozen of these provisions don't mean anything to my practice. If it includes a site safety provision, however, it very well could create significant exposure to you. So pay close attention to your contracts, because if you don't have, if you have contracts that include site safety obligations or which do not disclaim site safety obligations, you may find yourself stuck in litigation related to one of these nasty claims involving personal injury, which I can tell you is not where you want to be.
Great point, Jonathan. Let me ask one more practice management question. What should firms instruct their employees about being out on site and making sure that by your actions, you may have great language in your contract, but one of the things that people should be wary of is that their actions on site could lead them to be held responsible. Can you speak a little bit to that?
Sure. So there's always an ongoing debate about whether you should strictly follow your contract and stick your head in the sand versus if you see something, say something. I tend to trend in the direction of if you see something, say something. Here in Washington, D.C., the example we use is if your mother would be disappointed in you if an article was written about what you didn't do and somebody got injured and it was on the front page of the Washington Post, that's probably a sign that you should probably be saying something. But just being on a construction site creates exposure. I can tell you we've had clients over the years who have received OSHA violations, not related to things that their own employees were doing, but related to just being on site within observation range of folks walking around without a hard hat or working on a roof without appropriate safety equipment. So our philosophy tends to be see something, say something, and that helps to minimize risk, and it avoids people saying that you didn't care about the person who ultimately was injured.
Okay, let's go to the next one, Jonathan.
So this case takes us up to New York and involves a construction worker who was unfortunately killed during the construction of a connection between the Delaware and Catskill aqueducts. The construction worker was conducting a concrete pour into a formwork that had been constructed by the general contractor's carpenters when the structure collapsed and killed him. The construction worker's estate sued the city, who in turn sought indemnification from the general contractor and from the, quote, safety engineering firm pursuant to contractual indemnity provisions. Anytime you're reading a decision about site safety cases where the appellate court refers to the engineering firm as the, quote, safety engineering firm, close quote, you know that what direction the decision is going to go. But in any event, the trial court in this particular case dismissed the estate's claims against the city, and that consequently resulted in the dismissal of the indemnity claims because although it was largely a city-based project, the work and the location of the injury was in New Jersey. And so as a consequence, the trial court found that there was not a viable claim against the city. On appeal, however, that decision was reversed, with the appellate court finding that there was a question of fact as to whether the city had the authority to control the inspection of the formwork at the time, even though it was in New Jersey. The thing that's most remarkable when you're reading the case is the description of how no one seemed to follow any of the QA/QC plans. And I'll submit to you that anytime you are involved in a personal injury case involving wrong construction-related issues, and the testimony is that basically no one was following any of the required plans for quality assurance and quality protection that would have resulted in a safer means of construction, you're looking at a pretty scary case. So the court ultimately, if we can move to the next slide, Nahom, found that the estate was not barred from recovery under labor laws. And so what's the takeaway from this? It's really, you want to be, if you're involved in site safety, if you're involved in performing QA, QC type services, you want to be very precise in your contract language. You also want to be very diligent in making sure that your team follows through on what they're supposed to be doing. And those are going to be your best mitigation efforts. I'm sure you've seen a number of publications over the course of the past year or so about social inflation, which is a phenomenon we're experiencing on the litigation side that is associated with increased jury awards associated with personal injury cases. And it's cases like these and site safety issues that create those significant jury verdicts and create significant exposure for design professionals.
Thank you, Jonathan. This is indeed very sobering. We are indeed looking closely at bodily injury type claims, and our next webinar, actually next month, relates specifically to that. So we'll be spending more time on that topic. So let's go on to a topic that most firms are somewhat interested in, limitation of liability. Could you?
Sure.
Yeah.
Hopefully we can turn from some of the doom and gloom to perhaps some better news. So this takes us to Kentucky, and it involves a landfill project, the sexiest of all projects, I think. The owner of a landfill engaged geotech to perform services related to their facility between 2008 and 2018. In 2008, when they were first engaged, it was to perform an analysis of cracking issues associated with a perimeter berm. And the geotech, after performing a field visit, recommended that the berm be reconstructed, but also recommended that further geotechnical investigation be undertaken to confirm the validity of that recommendation. In 2009, after conducting 3 borings, the geotech affirmed its recommendations from 2008 and then worked with the owner hand in glove to rebuild the existing slope. The owner rebuilt it with their own personnel, and the geotech was on site to provide quality assurance and observation services during construction. During this period of time between 2008 and 2011, there was no written contract between the owner and the geotech. In 2014, 3 years after the slope had been rebuilt, the owner again observed tension cracks in the slope, and they re-engaged the geotech, this time pursuant to a written contract with a limitation of liability provision capping their liability at the amount of either $50,000 or their fee, whichever was greater. In 2017 and 2018, the parties again entered into 2 subsequent contracts, both of which included a similar limitation of liability provision. In late 2018, so after the services that were performed without a contract and after services performed pursuant to 3 different contracts, the slope experienced a significant lateral movement, and the owner terminated the geotech at that point in time and engaged a new geotechnical firm to review the situation. The new geotechnical firm concluded that the original geotech should have and failed to conduct sufficient or adequate investigation as part of their services in 2008 to 2011. And if they had done sufficient exploration at that point in time, it would have led them to conclude that the rebuilding of the slope was an inappropriate solution and that the owner should have gone with a different solution to overcome their challenges. It's always funny how in cases like this, the opinions of the experts seem to fall squarely outside the realm of a limitation of liability. So in this particular case, the engineer moved for summary judgment, at least as it related to the services performed after 2014 based upon the limitation of liability services, and the court enforced the limitation of liability provision, capping the engineer's liability at $135,000 for the post-2014 services. Because there was not a contract with a limitation of liability provision for the pre-2014 services, however, the limitation of liability cap was not extended to those. So the takeaway from this is that the trial court held that it was the limitation of liability provisions were enforceable as to some of the claim, but not as it relates to all of the claim. The lesson to be learned, or the question you might want to be asking yourself, is how might you ensure that your limitation of liability provision encompasses, your pre-contractual or multi-phase services? For example, I know many architects, you get the jump start to get rolling on your work, and then ultimately you sign the contract that's going to be the written document that memorializes everything you've done. Well, you might choose to include a retroactive date to the date of the enforceability of the contract, as one example. Therefore, you now have a contract if it includes a limitation of liability provision. If the contract has an effective date of whatever date you start your services, then you should be covered, I would imagine. So that's one approach you might choose to take to try to make sure that your limitation of liability provision really covers the full array of services that you provide to a client.
Great point. Thank you, Jonathan. Before we go into indemnity, can you just briefly, because we throw this term around in this industry, and I think it's important that we briefly define what indemnity itself, indemnification means before we go into this next case.
Well, my favorite part of indemnification as a concept is that I think that it's a widely misunderstood term, even amongst lawyers. Conceptually, indemnification is a concept that arises out of what are called third-party claims. And what is a third-party claim? A third-party claim is where there's somebody you don't have a relationship with who asserts a claim against the party you do have a relationship with, related to the services that you've provided. So, for example, an owner of a hotel that you design gets sued by somebody who trips and falls on a set of stairs that is allegedly improperly designed. The third party, the person who trips and falls, asserts the claim against the owner, and then the owner seeks indemnity from you. Over time, the law, because lawyers ruin everything, right? The law has developed in a way where in some jurisdictions, the concept of indemnity covers first-party claims. But the concept is really, if you've done something wrong, the party who has suffered an injury as a consequence of your wrongdoing, with whom you have a contractual relationship typically, should be reimbursed for the costs and the damages resulting from your wrongful conduct. In most situations, or in many situations at the very least, the concept of indemnity is directly parallel to a plain vanilla breach of contract claim. But the concept is that they're being reimbursed for costs that they've incurred that they shouldn't have had to incur, whereas a breach of contract claim is, I want you to pay for the damages regardless of whether or not I've incurred them and spent the money already.
Okay. So let's get into the next case.
Yeah, so we're going to head down to the bayou, to Louisiana. And this particular case involved a 28-acre mixed-use development, which included apartment buildings designed by an architectural firm to include a fire suppression sprinkler system comprised primarily of CPVC, a particular type of product. You're probably looking at the images on the screen and wondering, why are there pictures of people applying BoraCare, a mold control product, on walls, and we're talking about a fire suppression sprinkler system? And the answer is that during the course of construction, a subcontractor on the project sprayed this product within the vicinity of the CPVC pipes to prevent mold growth and mildew on the interior walls. At some later date in time, the fire suppression sprinkler systems began to leak and had to be replaced. The owner's insurance carrier, through what's called an owner-controlled insurance program, or an OCIP, paid to repair the damage. The OCIP provided insurance coverage that covered the owner, the general contractor, as well as subcontractors who were involved in the construction who opted into the program. The manufacturer of the CPVC pipe, however, was not part of that program, and so they were not covered. And the OSIP insurance carrier filed a suit against the manufacturer, in essence alleging that there was a defect in the product that they supplied. The manufacturer, in turn, asserted a claim for indemnification against the architect, alleging that the architect's design was flawed and or that it failed to catch the improper application of the Boracare with mold care product. I guess that in this, although it's not specified in the decision, it reads as though the design required the application of this product, perhaps because of the climate in the bayou. But in any event, the architect moved to dismiss the claims by the manufacturer, arguing that under Louisiana law, the manufacturer could only be held liable for its own fault. It couldn't be held liable for any wrongdoing of the architect, and therefore there could be no pass-through liability that could be asserted by way of a third-party complaint. The court heard that argument, but ultimately denied the motion to dismiss, finding that there might be some factual outcomes that would allow the claim to be pursued. And so the manufacturer was permitted to proceed with its indemnity claim against an architect. Oftentimes in cases, we see indemnity claims asserted because they are conditional in nature. It's in the event that the plaintiff pursuing a claim against me prevails, then I get to prevail on my indemnity claim. And so there's a conditional element to it. But here, how can a possible indemnification obligation owed to a non-client be avoided by contract? Well, you might have a provision in your contract that says there are no third-party beneficiaries to our services. One of the things you learn over time as you read these cases is you don't have insight into all of the provisions of the contracts and all of the facts, and so sometimes you don't know whether there are elements that have been strategically saved as an argument for a later point in time, but there are certainly things you can try to do to minimize the risk of getting sucked into an indemnification claim like this.
Okay, all right. Well, let's go on to the next case, Jonathan.
Yeah. So this case is one of my least favorite of the program because it involves design professional on design professional violence. In this particular case, the contractor sued a surveyor alleging that deficient surveying services as part of a federal construction project resulted in improperly installed piles. The surveyor's scope of work included staking test piles, staking production piles, providing a post-cutoff pile as-built survey, and then performing anchor bolt checks and verifications. The plans provided by the engineer for the project to the owner, to the contractor, then to the surveyor included the following general note. Elevation 100 feet corresponds to mean sea level elevation 103.5. The surveyor did not necessarily pick up on that particular nuance, and as a consequence, 160 of the 535 piles were installed at an incorrect elevation, allegedly due to the surveyor's failure to account for this general note. The consequences, there was a redesign which required 71 tons of additional rebar, 350 cubic yards of concrete, and 5,024 cubic yards of additional backfill, not to mention a critical path delay claim where the contractor sought to recover $3,300 per day of delay. The surveyor, staring at this ugly situation and potentially significant dollar figures, asserted a claim against the design engineer, arguing that they breached the standard of care based on a failure to bold, enlarge, highlight, distinguish, or otherwise call attention to the note altering the use of the standard mean sea level elevation in the plans. The surveyor alleged that the typical practice on federal projects is to use mean sea level elevation and not to make modifications, and so the design engineer was in fact at fault for their survey issues. The design engineer moved to dismiss the surveyor's indemnity claims against the design engineer, and those claims were in fact denied, and as a consequence, but there were other claims related to negligence that were allowed to survive. But the indemnity claims were dismissed because there wasn't a contractual privity or privity equivalent. So if we could go on to the next slide, to the lesson learned. The takeaway from this is that courts usually look to the written terms of your contract to understand what indemnity obligations may exist. That is, courts are reluctant to impose indemnity obligations that are not found in your contract. And so one thing you might want to be looking at is, do your contracts entitle you to indemnity for claims caused by or damages caused by other people? Just something fun to think about. Next case. Oh, yeah. Go ahead.
Go ahead. No, let's move on. Go on.
Yeah, the next case takes us back to New York. This case involves a project which I'm sure some of the folks on this webinar have encountered. That is where the original architect has replaced with a replacement architect. Here, the owner contracted with an original architect for the restoration of 7 mixed-use properties. After the plans were developed, the owner discharged the original architect and engaged a replacement architect. That contract with the replacement architect included an express obligation for the owner to defend and indemnify the replacement architect related to claims which may be asserted by the original architect against the replacement architect in connection with the replacement architect's use of reproductions of plans and drawings. So in essence, the replacement architect had some foresight to see there's a possibility the original architect might want to assert a claim against me for stealing their copyright. And that is in fact what happened here. When the original architect sued the replacement architect turned to the owner and said, honor your contractual obligation to defend and indemnify me. And they asserted a claim against the owner to that effect. The owner moved to dismiss the claim, arguing that the original architect's claims against the replacement architect included an allegation of intentional infringement. That is, they knowingly copied the original architect's plans, and so therefore the indemnity provision was unenforceable as a matter of law because intentionally wrongful acts are not the type of thing that courts will enforce indemnity provisions over. So sounds like a great client to have. Here, can you help me out by taking over for somebody? And I'll even agree to indemnify you if they choose to sue you. But when that actually happens, I'm going to try to welch on the deal. Great client. But in any event, the trial court denied the motion to dismiss, finding that until there was a finding by the jury of an intentional infringement, it could not conclude that the indemnity provision was unenforceable. The lesson to be learned is that you really want to be thinking about whether you need an indemnity provision in your contract if you're going to be taking over for a replacement architect. And you need to be thinking about whether indemnity provisions that you enter into, perhaps with consultants, would in fact be enforceable.
Okay, so let's go into fiduciary duty, Jonathan,
Sure.
that we can make sure that folks at least have an understanding of their exposures. So go ahead.
So our next case takes us down to Texas, and it involves a fiduciary duty claim. And you're probably thinking to yourself, fiduciary duty sounds like the type of thing that a lawyer owes or that owners of a business owe to their partners, and you'd be absolutely correct. But what is a fiduciary duty? It's a duty to put the interests of the person you owe the duty to ahead of your own, in not so many words. And in this particular case, it involved the development of Phoenix Estates, a development that I'm sure no one on this webinar has ever heard of. But the adjacent property owner sure knew about it. Phoenix Estates was a housing project, and during the course of construction, the contractor on the project severed the sewage line to the plaintiff's property, resulting in significant damage. The plaintiff, after this occurred, filed a lawsuit against the contractor and the developer and sought to enjoin the development of the housing project. That request was denied. Undaunted, the adjacent property owner filed a separate lawsuit against the engineer, asserting, amongst other things, a claim of breach of fiduciary duty based on its allegation that the engineer was required to provide a water detention plan for the project, but failed to do so, resulting in water and mud intruding into the plaintiff's warehouse. The trial court granted summary judgment in favor of the engineer, finding that an engineer under Texas law does not owe a fiduciary duty to a non-client. On appeal, that decision was affirmed, but I think it's really important to understand the argument that was advanced by the adjacent property owner, which was that the licensure statute in Texas stated that, quote, engineers shall be entrusted to protect the health, safety, and property and welfare of the public in the practice of their profession, close quote. And it's that word entrusted that gave the hook for the assertion of this fiduciary duty claim. While the appellate court affirmed the trial court's decision and found it was nonsense for the adjacent property owner to pursue the claim, the lesson to be learned is that you need to be wary when you're assuming or performing work of a contract to make sure that it does not include fiduciary duty claims, that is, duties to put the owner's interests ahead of your own. There are coverage issues that can arise from that, but the easiest way I think about it is, do you really want me to put your own financial interest ahead of performing my services in accordance with the standard of care? That doesn't seem to really make sense to me. So something to be aware of when you're signing contracts. If you see the words trust, confidence, relying upon you to look out for them, those are buzzwords you should be looking for when you're reviewing contracts to make sure that those get removed from your scope of work.
Great advice, Jonathan. So let's then transition to some licensure issues that relate to some of the topics that you just
Sure. So what better place to start than New Jersey with a pay-to-play scheme? This particular licensure case involves an engineer who was employed as an officer at an engineering firm. And as part of his compensation, the engineering firm paid him bonuses that he was then instructed to use to make political campaign contributions. Sounds like New Jersey, right? So the engineer ultimately is caught. The firm actually dissolves and goes under because of this entire scheme. But the engineer pleads guilty to a fourth-degree offense of making a campaign contribution to persons running for public office in the state of New Jersey. After he pleads guilty, and here's the statute, after he pleads guilty, the New Jersey Board for Professional Engineers revokes his license, but allows him to apply for reinstatement 5 years later based on his conviction being a crime relating adversely to the practice of engineer. And you can see the general requirements, by engaging in practice that involves the use of dishonesty, fraud, deception, misrepresentation, false promise, or false pretense. Those types of And similarly, if you look at subchapter F, this is from the New Jersey Licensure Board, but I can tell you that almost every other licensure board across the country has similar language to this. This is what led to that sanction. The engineer, though, or I guess the former engineer, was not happy with that finding and appealed the decision, arguing that the board did not take timely action because the decision to revoke his license occurred 7 years after he was indicted and 3 years after he pled guilty. And so he had a false sense of security, was his complaint, related to his ability to continue practicing engineering. And the New Jersey appellate court that reviewed the board's decision looked at him askance and said, there's no reason for us to disregard the board's findings. And so his license was revoked based upon that illegal campaign contribution that he pled guilty to. The lesson learned, committing a crime can have significant professional consequences, regardless of whether the crime is directly related to your professional practice. The next licensure case takes us out to Minnesota. This is the case of Marone versus Minnesota Board of Architecture. Mr. Marone was an engineer who acquired his license in 2000 and practiced for 12 years. In 2012, if we can get to the picture, you see Mr. Marone. He ceased practicing engineering to fully commit himself to his nonprofit organization, Strong Towns, a nonprofit that advocates for local governments to spend fewer taxpayer dollars on infrastructure and construction, which you may ultimately think is odd for an engineer, but I guess the concept is if you don't invest in infrastructure that allow people to live in the suburbs, that people have to live in towns, and it improves the quality of towns. But even though he stopped practicing in 2012, he maintained his license until 2018. These, by the way, the images that you're looking at are some of the policies he's advocated for. In March of 2020, he was reported to the board anonymously for holding himself out as a professional engineer when he was at a time when he was unlicensed, because his license lapsed in 2018, and he continued to hold himself out and report himself as an engineer in publications and biographies that were disseminated at speaking events. In June 2020, before he knew about this licensure complaint, he reapplied for licensure because he realized that he'd forgotten to renew his license in 2018. The renewal application included a certification that he had not held himself out as an engineer during the period that he was not licensed. Checkmate. In July 2020, the board contacted him because they'd received the anonymous reporting from March of 2020. They received the June 2020 application, and they said, have you been practicing engineering? And he again said no. After he doubled down on his misrepresentation, the board issued a letter to him about the violation, and that included a settlement offer. He just needed to stipulate to having made a false statement and pay a fine of $1,500. The engineer refused. Instead, he filed a complaint seeking declaratory relief that the statute permitting the board to regulate the term engineer in Minnesota violated his First Amendment rights. The federal trial court looked at that argument and dismissed it out of hand, finding that it lacked jurisdiction to decide the case based on a legal doctrine which limits federal court involvement in matters of important state interest, such as a state's ability to regulate its own licensed professionals. And so as a consequence, the state board was permitted to discipline a non-practicing engineer for holding himself out as licensed. The lesson to be learned from this: regularly audit your licensures to avoid inadvertent violations, because those inadvertent violations, you may get a slap on the wrist in one jurisdiction, but if you have to then report that slap on the wrist to other jurisdictions, there could be cascading consequences if you practice without a license. Our next case, oh, go ahead.
No, sorry, go ahead, Jonathan, sorry.
Next case takes us down to sunny Florida, and this particular case involves, again, an original architect, replacement architect project. The original architect was contracted by the owner to design a new hotel project. After the original architect signed and sealed a permit package, the owner terminated the original architect and retained a replacement architect to revise, sign, and seal a new set of plans. Subsequently, the owner filed a lawsuit against the original architect related to defects in the original architect's design that were discovered during construction. As an affirmative defense, the original architect cited to a Florida licensure law which provides that a replacement architect must assume full responsibility for a design upon signing and sealing a set of plans. In other words, the original architect said, this licensure law is a get out of jail free card. The owner moved for summary judgment on this affirmative defense, arguing that the Florida licensure law was relevant only to board proceedings and was not a viable defense in that it didn't absolve the original architect of liability for their services. It just said that the replacement architect was also liable if there was an issue that was not caught. The federal trial court agreed, finding that the licensure statutes are intended to make sure that architects meet minimum requirements to protect the health, safety, and welfare of the public at large, not to serve as a shield to protect themselves from their own mistakes. So the architect was required to then proceed with defending itself against the lawsuit, despite there being a successor architect who had assumed professional responsibility for the design. The lesson to be learned: absent a contractual provision that says you're not going to be responsible for things if you're not involved on the project, or absent a release agreement, merely being terminated from a project does not provide protection against future liability. If you are going to separate from your client, you ought to be thinking about, I want to get a release in exchange for my license, a license to use my work product without me being involved. And that's something you should be thinking about getting and trying to obtain before you fully walk away from a project where the relationship with the owner has turned sour.
Oh, great point, Jonathan. And so I think this brings us to our last case, I believe.
Absolutely.
Of subrogation.
One of my favorite topics because of the name.
Go ahead.
Yeah. So subrogation. Whenever I talk to a client, they look at me cross-eyed about what is subrogation. In normal person speak, it's somebody who steps into the shoes of another, and typically it applies in the insurance context. If an insurance carrier pays out a liability, they are subrogated to the rights of their insured, meaning they get to step into the shoes of their insured to pursue claims against parties who may be liable to their insured for those damages. This particular case takes us just outside of Chicago to the Oakton Community College project. I think we actually have a picture of the there it is. Beautiful, beautiful project. This particular case involves a community college which contracted with an architect to design the Lee Center on its main campus. During construction, the concrete slab that was poured settled by as much as 2 inches in an unanticipated manner. The community college then sued the contractor as well as several design professionals, including the architect. The architect moved for summary judgment based upon a waiver of subrogation provision in the construction contract, not their contract, the construction contract, specifically the A201. And the construction contract included a clause as it was modified to read, the owner and contractor waive all rights against the architect for damages caused by fire or other causes of loss to the extent covered by property insurance or other property insurance applicable to the work. The contract also included an all insurance or an all coverage type of insurance. And so the architect moved for summary judgment, arguing that this clause in the construction contract entitled it to summary judgment because this waiver of subrogation clause prevented any claims from being asserted against the architect, because all of the claims were agreed to be absorbed by the insurance carrier. The court, the community college argued, look, the architect's not a party to this contract, they don't get to enforce the construction contract, and the court looked at the community college askance and said, it's obvious that they were an intended beneficiary of this clause, and so as a consequence, we're going to enforce the waiver of subrogation provision and dismiss the claims against the architect. And that's the happy note we get to conclude our program on today. The lesson to be learned: you want to have waivers of subrogation in all of your contracts. We tend to see claims brought by insurance carriers who are subrogated to the rights of their clients only in the most catastrophic of situations where there are multi-million-dollar claims. And the waiver of subrogation clause can be an absolute bar and barrier to a claim against you where you might not even be named because the insurance carrier who might pursue that claim recognizes it's not a viable claim and they want to spend their resources in other directions. So always make sure you have a waiver of subrogation provision in your contract.
Thank you so much, Jonathan. We are right up on time. This was an excellent synopsis of challenges that our firms face that I'm glad we got to end on a positive note. And so I just want to bring to your attention some housekeeping issues. Look for that survey and the downloadable certificate. And remember to fill out the survey. There's some resources that are available on our website for those of our insureds. You can find our new contract sifter and next to it our on-demand risk management courses for design firms. All of these are free as part of our program if you happen to be an insured of ours. The programs are accredited for continuing education credit. So just be on the lookout for all of the resources that are available to you. And then finally, next month, our webinar, as I alluded to earlier, is on bodily injury claims. This is scheduled for April 18th. Registration is already open, so please go ahead and register for that. Thank you all so much for your attention, and I appreciate your attendance. Please fill out the survey and provide us the feedback that we're asking for, and we will conclude today's presentation.